In this lesson, we're going to cover everything you need to know about consent as it's described in the procedural safeguards or parents' rights. Before we get into specific information about parental consent, let's start with the definition. You'll see that parent consent has 4 parts to its definition. In order to provide consent, parents must be fully informed about all of the information related to the action for which you're about to give consent. The procedural safeguards say that in order to be fully informed, parents have to receive relevant information in their native language or other mode of communication. Simply put, before you can provide consent, you have to know and understand what you're consenting to and why it needs to be done. Next, in order to meet the definition, parents have to agree in writing to the action the district is seeking consent. Typically, districts will provide a consent form to parents that has space for parents to acknowledge what is being proposed and provide a signature to show their agreement with the action. The third piece of the definition of consent is ensuring parents understand that they can revoke or cancel their consent in writing if they change their mind. If a parent revokes consent, this means that the district can no longer continue with the action. Even though parents always have the right to revoke consent, it does not undo actions that the district has already completed. If a parent revokes consent, for instance, once an evaluation has been started, the district cannot undo the evaluations that have already been completed. The results of the completed evaluation components will continue to be part of the child's records. However, the district will not be able to complete any further parts of the planned evaluation once consent has been revoked. Finally, if a parent revokes consent for special education services after the student has received them, the district does not have to remove references and evidence of the special education services provided from the student's record. Plainly put, parents can revoke consent and stop actions in the future, but they cannot erase what was already done. Let's look at when districts will ask parents to provide their consent. Under the IDEA, the federal special education law, parents must provide consent before specific actions can be taken by the school district. Consent is needed before a school can conduct an initial evaluation or a re-evaluation of your child, before a school can provide special education services to your child for the first time, and before a school can invite other agencies to participate in IEP meetings, usually to discuss transition services. In addition to those 3 situations, different states may have additional consent requirements. Parents should always be familiar with state-level requirements. Contact your district, the Colorado Department of Education, or your federally funded parent center if you have questions about when consent is required in Colorado. An initial evaluation is required to determine if a student meets eligibility requirements for one of the 13 potential disability categories under the IDEA. Students who are referred for an initial evaluation cannot be evaluated without their parents receiving a prior written notice and providing parental consent. School districts are obligated under the IDEA to find, evaluate, and identify students who they have reason to suspect may be a student with a disability. This requirement is known as the child find obligation of the IDEA. Because of this requirement, districts are also required to make and document all attempts they make at seeking consent from parents for an initial evaluation. If parents do not respond or refuse to provide consent, the district has few options as to how to proceed. First, they can do nothing. If parents refuse to provide consent for an initial evaluation, the district can continue educating the student as a general education student. By seeking a parent's consent, they meet their child find obligation and are not required to take additional actions. But there are additional actions they can take if they feel strongly that the evaluation is necessary. A district can choose to use the dispute resolution procedures to compel a parent to provide consent. This is rare, but it can happen. Let's look at a scenario to help us understand. Imagine a 3rd grade student who is struggling with significant behaviors. The student becomes aggressive and self-injurious. The school team tries interventions to decrease behaviors and is not having success. Behaviors are escalating, and the parent does not provide consent for further evaluation. In a scenario like this, the district has significant concerns and feels the initial evaluation is critical. They can choose to file a request for mediation or a due process hearing where a judge will decide whether an evaluation is needed and potentially override the parent's decision not to provide consent. It's rare, but it is allowable.